Thanks. So just a little bit of background and maybe a little bit of how I really got involved in this journey, this ACP journey. And I see an accomplice that's with us, Honey Goodman. Honey and I have been very much involved in this together as well. But um, in quite a few years ago, over a decade ago, close to 15 years ago, I got involved at a national level with regard to critical care and really making some changes so that patients didn't show up in ICU without any kind of indication what kind of treatment they wanted. Because in critical care, we're basically going to say, well, these are the things we can do. And if we don't know what you want and what you don't want, we're probably going to assume that you want everything that we have to offer. And that's not always true. So as I've talked to people throughout the years, I've really told them that, part of the responsibility is on us as professionals to make sure that we make the opportunity, information, and the awareness of ACP available to the public. But then it's their responsibility to actually take action with as themselves and with their family members to have those kinds of discussions. So back in 2008, this is a personal story for me. I don't know if Honey knows this or not, but there was this group called Idaho End of Life Coalition. And I heard that they were working on changing some language in the one of the statutes, the developmentally disabled statute, and also in the Medical Consent Act. And I thought, I want to be involved in that because of a professional story I was having in one of the ICUs at the time. It was a developmentally delayed patient that was intubated, had a breathing tube in, and the guardian for that patient was the patient's brother. And there was absolutely not even a second that we ever doubted that he had the best interest of his brother who was laying in that bed, um, in his own mind. And so as we went along talking about treatments we could do and things we could help to improve the situation, his brother was very much involved in that. But we came down to the point where we weren't really making progress. And if it were you or I, um, um, probably the recommendation would have been things are not improving. In fact, they're taking a turn for the worse. Probably the right thing to do here is to choose for a dignified death. But the law at the time would not allow for us to do that. It basically did not allow for a guardian to choose a DNR status for a developmentally delayed person. So that's what got me involved in all of this back in 2008. And so ever since then, I have only gotten deeper involved, and not only at the local level, at the state level, but also now at the national level in my own national organization for the National Association of Clinical Nurse Specialists, but also for the National Post. I am the state representative for the Idaho Post on that board. So anyway, I have a lot of passion about this. And so as I talk about it today, I'm hoping that you have a great deal of passion for this as well. And hopefully I'll leave you with some, at least even one gem of information that you can take away from this presentation to not only improve the lives of those that you serve, but also improve your own life and your family's life. So go ahead and advance the slide, please. And keep on going. Probably two more clicks. One more click. Perfect. So three of the objectives I want to cover today are these three that you see on the slide. So identifying and understanding the roles of advance directives, including related misconceptions and concerns of patients and clients. And then also understanding the elements of advanced care planning, because advanced care planning is broader than advanced directives. And you'll understand that at the end of the presentation when I talk a little bit about the Idaho Post. And then lastly is understanding the role of decision-making capacity in addressing advanced care planning and healthcare wishes. So I'll go ahead and advance the slide. And I think you can probably click probably about 5 times. That's, yeah, probably one more time. So, you know, it's interesting that nearly 70% of all Americans say that they don't want to die in a hospital. But they do. And 7 out of 10, like I said, 7 out of 10 Americans said that they prefer to die at home. Interestingly enough, only 25% of Americans do die at home. And then greater than 80% of patients with chronic diseases say they want to avoid hospitalization and intensive care when they are dying. But the chances are, if they don't have an advanced care planning document, they will end up in ICU. The sad thing is, and this is kind of the culmination of this problem, is only 20 to 30% of Americans report having an advance directive. And so even when they do have an advance directive, so this is one of the things that I want you to take away from today, is if you have an advance directive and you don't tell your healthcare professionals about it, if you don't share that with the hospital that you frequent or the clinic that you frequent, then they will not be able to address the things in that document. That document is only as good as how many people have it in order to make a decision with it. Next slide, please. So the problem is, and this is what I deal with in critical care, with no advance directives, families who don't understand or know your wishes, and that's not an uncommon thing. You think it is, but it's not. You could have a brother that's in ICU. You haven't spoke to your brother in the last 5 or 6 years. Your brother took a turn for the worse health-wise. He's really not been doing that great the last 3 years, but you really haven't, talked to each other, and that's just the way it is. So that puts you in an awkward position to make decisions for your brother. And others could step forward and have to make decisions for you under Idaho's Medical Consent Act. And literally, if you look at the list of people in that, it could end up being somebody who doesn't even know you. It could be your second cousin 3 times removed, Uncle Albert, who you scares the heck out of you every time you've seen him in your life, and you don't want him making decisions for you. So do your advanced care planning. Also, without an advanced care plan, we don't really have anything documented regarding your treatment wishes. And so if we have family members that are saying that, well, I know what my brother would want, he would want this. And we got somebody else that's saying, well, I know what my brother would want, and I think he would want this, so I totally disagree. Well, then we have this conflict, and there have been times that that's resulted in court. And I guarantee you that court is the last place that we want to go for making treatment decisions. But sometimes that's where we end up. Next slide, please. So I'll let you take a look at this. So, it's not a casual conversation. Advanced care planning is not a casual conversation. So just be clear when you say what you say, that the recipient of who you said that to really truly understands what you mean. Next slide. So that kind of brings me to the healthcare power of attorney. So that is that person that you're going to talk to. First and foremost, never, ever, ever name somebody in your advanced care planning documents as a healthcare power of attorney without telling them you've done so. That is the rudest thing ever. We've had patients come in. Let's say, for instance, the patient registers their advance directive in the Idaho Healthcare Directive Registry, and we find it, we pull it up. It lists their sister on there, gives their sister's number. We call their sister, and their sister says, "God, I haven't talked to my brother in 20 years. Why are you calling me?" Well, he had you listed as his healthcare power of attorney. Oh, well, I had no idea that he did that. I don't know what he wants. So it's not just a process that you want to follow. These things, all advanced care planning starts out with a really well structured conversation. And that doesn't mean you need a healthcare professional to be part of that conversation for an advanced directive, but it does mean that you need to make sure that if you're giving advice to a client or if you're talking about your family or yourself, that means that they need to know that this is not a casual process. So you name somebody else that's going to make medical treatment decisions for you if you cannot make them for yourself. Don't just assume that that's your spouse. I've talked to plenty of people over the years that say their spouse would not have the guts to carry out the things that they have in their advance directive. And so they chose somebody else, and their spouse actually is grateful for that. Secondly, agents do not sweep in and automatically start making medical decisions for you. These things only in an advanced directive, these things only come into play when you can't make your own decisions, and that'll come up later in the presentation. Also, it's important that you make sure that there's some kind of documentation regarding HIPAA release in your advanced directive, because we want that person to have full access to your medical record if they're going to be expected to make those decisions. And then I've already talked about giving careful thought to the people you name. And then it's important, in addition to that one person, you really should at least name one other person, if not two, as alternates. And that's exactly what they're called, because it may be that you just didn't update your advance directive when your healthcare power of attorney passed on, or got dementia, or is out of the country for 3 years and unavailable for whatever reason. That's why you want the backup. Next slide, please. So this is what you actually see if you pull up the Honoring Choices Advanced Directive. And I really like the Honoring Choices Advanced Directive information. It is very well spelled out. It's very well organized, and it's logical. Its workflow is logical. So the very first section that you're gonna fill out is this healthcare power of attorney, and you notice that they call this person several different things. It could call it healthcare agent, healthcare power of attorney, durable power of attorney for healthcare. So just know that those are the different things that you might see on different advanced directive forms. So you're going to put that information down, and you're going to put your first choice, then you're going to put your alternate choices. And so that's the way you start on this journey. Next slide, please. So, earlier when I was talking about who exactly might be deciding for you if you don't have an advance directive. So, first of all, if you have a guardian, an advance directive is not going to be, it'll be referred to with regard to your wishes, but if you have a guardian, you can't have at the same time a healthcare agent. So the legal guardian is the person who's going to be at the top of the list. If you have a healthcare agent or a durable power of attorney for healthcare, that's number two. Number three is your spouse, if you're married. Number four is an adult son or daughter. Five, a parent. This is where it gets down after a parent. This is where it gets down to pretty much could be anybody in your life, and might not be somebody that you want acting in your behalf. Could be any relative, could be any other competent individual representing himself or herself to be responsible for the health care of you. And lastly, it could be the attending physician if none of the previous people were able to find. So, and that has been the case with sometimes with patients that come in and they're a John Doe, and we don't know anything about them. Next slide, please. So just a little bit of a common myth. Your agent under healthcare power of attorney has the right to make all healthcare decisions on your behalf and can even make decisions over your objections. So if anybody ever tells you that, or you've heard that before, that's absolutely not true. Your healthcare agent has no authority to give any healthcare directives for you unless you're found to be unable to make your own decisions. So only then does their power become active. And in addition, your healthcare's responsibility is to communicate the best of the agent's ability to the best of their ability, what your wishes will be. So some of the things, some of the times, what we get into the crux of in healthcare when we're talking to families is, let's say we have a patient that's on the ventilator and on dialysis and all these things, and things are not going well at all. So we meet with the family and we say, well, here's the situation. What would you like to do? Well, that is absolutely not the right approach to set the family up for success. It's not a bad thing to say that, but here's the better way to say it. And kind of listen carefully, and you should hear the difference. So I sit down with the family, things are not going well. Knowing your brother like you do, what would he want you to do? Can you hear the difference in those two messages? So we're not saying, what would you want to do? What would your brother want you to do in his behalf? So that sets the surrogate up for success in framing their response, in acting on behalf of the patient rather than acting on behalf of what they would want. Next slide, please. So the second component of an advance directive is a living will. And basically a living will is, there's standard information, there's like the basic living will, but a living will can comprise anything that talks about your wishes, your treatment wishes. And in Idaho, the combination of the healthcare agent and the living will is known as the healthcare directive or advance directive. And essentially, any adult person may execute a directive directing the withholding or withdrawing of life-sustaining treatment in a terminal condition or permanent unconscious condition, and is required to be signed by the declarer. So that's a standard out-of-the-box living will. The directive can specify further details, but oftentimes when people just pull those forms off the internet, they check the boxes and they sign it and they move on their way. They don't realize, by checking those boxes without really having a good conversation, how much that can actually influence treatment decisions that maybe they don't want any part of. So again, carefully have a conversation with your family, with your healthcare agent, to really make sure that the document you create is well crafted. Next slide, please. So the other thing, if you fill out the traditional living will, the one with the check boxes, it really is a limited application. And like I said earlier, it only is activated once these things have been met. And when I get to the post, I'll tell you why that is so much different. But I like the Honoring Choices Idaho process better because it adds another added detail. So we're going to talk a little bit more about the living will here before I transition to that third element. So if you can, next slide, please. So option one is kind of the, I want everything. So oftentimes, if you're 18, filling out an advance directive, and you're in the, you think you're in the prime of your life, I'd say that doesn't happen until another couple decades at least. But anyway, you fill this out thinking, you know what, I'm not going to die. If I get into a situation like a truck hits me or whatever, I want everything done. So then as the choices go along, this next one is really focusing on artificial nutrition and or hydration. And it's basically saying that if I'm unable to communicate, and then there are some things that might apply, like artificial nutrition and hydration, that you want those. You want those. And then you can check down here and provide greater clarity. So you only want hydration of any nature, whether artificial or non-artificial, or you only want nutrition, whether artificial or non-artificial, or you want both nutrition and hydration of any nature. So that's that option. And then there's a third option. Next slide, please. And the third option is basically I don't want anything. Just if I meet those criteria that I talked about several slides ago, then I basically want you to withdraw life sustaining measures from me, and I want you to give me a comfortable death. And so that's the standard living will. You can see that it's really easy to check the boxes, but I will tell you from a critical care standpoint, there are so many other things that we consider when we're talking about treatment that this standard living will really does not adequately address. So next slide. This is where I want to talk about the personal value statement. And this is what I love about the Honoring Choices Idaho Advance Directive. It adds this other element that is a statement of your individual values and goals of care related to your end of life wishes. And so if you are at a point in your life where you have early onset dementia, but you're totally, you have full capacity, you haven't had any major problems yet, but you've had friends that have gone down that path of early onset to advanced onset to end stage Alzheimer's, then you know that at some point in time, gosh, I do not want to go through that particular part of it. If I get to that part, I just want things withdrawn and I want to have a nice, comfortable death. You can see that that other standard living will really doesn't get into that detail. That's what this personal value statement piece is. And again, this the reason why it's really important to talk to your family about this is as you look at these details that you can see in this form right here, it asks you some pretty good questions, some things to ponder. And you want to have those conversations with your healthcare professional, with your family. And if your healthcare agent's not part of either one of those, then definitely with your healthcare agent. Next slide, please. So, it talks the Honoring Choices Idaho walks you through a process where it talks about your goals of care. And it gives you some examples of things to consider. And then I like this phrase. If you come down to the middle of the page, and it says, again, imagine the following situation. A life threatening event has left you unable to communicate with those around you or to participate in your daily care, treatment planning, or decision making. Even though all the care and available treatments are being provided, your doctors have determined your illness or injury cannot be cured and death is likely, or your brain function will not return. I think that's a great scenario. That's actually not an uncommon scenario. So the question is, what would you want in that situation? Would you still want everything? Would you only want certain things? Or would you not want anything? And that's, if you look at this format here, that's very similar to the option A, option B, option C in the standard living will. Next slide, please. It also goes into cardiopulmonary resuscitation. And I think that, some people, lay people and healthcare professionals, some people don't fully understand exactly what that means. The American Heart Association definition of cardiopulmonary resuscitation is literally about providing artificial respirations and compressions. It has nothing to do with defibrillation. It has nothing to do with all the medications that we give. When I talk about CPR, I'm talking about BLS, basic life support. If you've taken BLS, a BLS class, that's what I'm talking about. And it could involve the use of an AED. But in the hospital, we have lots of other things that we employ if you have a code. And those things are called Advanced Care Life Support, ACLS. And those things involve the use of medications. And a defibrillator where you can defibrillate not similar to an AED, but you're actually choosing how much and when to defibrillate. Obviously, there's that breathing tube that's involved. That's the artificial respirations piece. So, what is it that you want with that situation? Again, it's the same situation. What do you want? Do you want everything? Do you want CPR or do you not want CPR? Next slide, please. So one of the common myths is a nursing home or assisted living facility can require you to have a living will in place in order to be admitted. If you've been told that or if you've understood that, that is not correct. Federal law prohibits a healthcare facility from discriminating against a patient for not having a living will or a healthcare power of attorney. Nonetheless, it is not uncommon for me, and we're getting better, I would say, through the years, but it hasn't been uncommon in the past for me to hear of healthcare facilities, assisted care facilities and nursing homes to suggest that one is needed. And they truly believed it. It wasn't that they were being mean or anything. They just had been told that. And so we're trying to, over the years, we've tried to do a better job about really helping them to understand exactly what it is that they do need. And what it is that they do need is a resuscitation status on file. So does your client want CPR or do they not want CPR? And so once you've recorded that on the patient's chart, then you've met the requirement. There is this other myth that if EMS are called to resuscitate you and you show a copy of your living will, that they'll respect your wishes. The problem is that EMS, because they are not licensed providers, they are acting under the direction of protocols from a licensed provider. When they show up on your doorstep, they are obliged to actually perform CPR and to perform emergency care services and then transfer you to a higher level of care. There's a difference in the Idaho statute between a living will, an advance directive, and those two things, and an Idaho Post. And I'll get to the fact where the Idaho Post does have some differences. And so that's what we're going to talk about now. So the Idaho Post is actually legally recognized throughout the continuum of care in Idaho. So that doesn't matter. It doesn't matter where you're at in Idaho, whether you're in a clinic, whether you're in an urgent care, ED, hospital, EMS, it doesn't matter. An Idaho Post is legally recognized. So it's intended to direct care consistent with your wishes. Kind of sounds like an advance directive, right? But it is not an advance directive. This is a physician's order, a provider's order. And I'll talk a little bit more about who is authorized to exercise that. So literally it's a one-page document. Next slide, please. It's a one-page document it's designed to help all of us that are trying to provide the care and the treatment with a quick way to see what are your wishes. And so again, it's a summary. It's not like 4 pages. Everything is on one page that's telling us what your treatment preferences are. And again, it is not going to have any information with regard to who your durable power of attorney is or anything like that, because it is a physician's order. So just a little bit about the story. Oh, can you go back a little bit? Just one slide. Sorry. Just a little bit about the Idaho Post.
As soon as I figure out how to go backwards on this.
Just if you click the down arrow, there you go, that's it. I want to give you a little bit of history. So back in 2007, the Post was enacted, but what did we have before then? We had this thing called a Comfort One. The Comfort One was a similar document that EMS actually utilized, but it was not legally recognized in all healthcare settings. So the POLST, POLST, was something that was started in Oregon, and then it's kind of spread across the nation over the years. And Idaho elected to go with the providers, the physician orders for scope of treatment. And I like to call it provider because it's not just a physician who can actually sign the form. So it must be followed except when these are three things that are identified in the statute. If the person who's rendering the care believes in good faith that the order has been revoked, or to avoid oral or physical confrontation. And if you ask me why that is in the statute, I don't know why. I've asked over the last several years. I honestly felt like there was probably discussion in some legislative committee, and they said, I want this in here, or I'm not going to support this bill. And I guess at some point, maybe somebody said, okay, fine, we'll put it in there. And then lastly, if ordered to do so by the attending physician. So if the patient comes in, they're accompanied with their family member, and there's an acute issue that, look, we just need to do this thing. And if we do this, the patient will have a very good outcome, likely to have a very good outcome and a quick response to that. But if the post says not to do that, then what are we to do? Well, if the attending physician talks to the family and the family says, well, yeah, my dad would want you to do that in this situation, then that's information that the statute would deem reasonable to act on. And then this is just a little bit of information. In 2012, we were able to actually lead a change to the statute, which authorized physicians, APRNs, which includes me and nurse practitioners and certified nurse midwives. And I don't know that an anesthetist would be signing a post, but they have the legal authority to. And then lastly, physician's assistants. Next slide, please. So if you do get a post, you can do a couple of different things. And so you see this healthcare directive card. I know I just told you a post is not a healthcare, it's not an advance directive, as we say in the traditional term. But in Idaho, we have only one healthcare directive registry. So if you want to register your advanced care planning documents, that's where you're going to have to go. And when you do that, it makes these documents readily accessible to healthcare organizations so that they can be able to look that information up. But important is that if you do register your documents on the Idaho Healthcare Directive Registry, you want to make sure that you share this information that's on this card, because if we don't have your filing ID and we don't have your password, then we can get your information likely Monday through Friday, no holidays, no weekends, when there's somebody there that answers the phone, but otherwise we wouldn't be able to. So this is the only way we can get it directly from the internet. Next slide, please. So what are our responsibility as healthcare providers? We need to encourage the submission of advanced directives and advanced care planning documents to the registry. That provides a secure place to keep these documents, makes them accessible to us. It also helps to stress the importance of carrying that registry card, and it helps to expedite the treatment consistent with your wishes. So we need to always ask that patient or the client, have you registered your advanced care planning documents? And if so, do you have that card on you? And if not, try to obtain that. Next slide, please. So under the Idaho statute in 2017, the guardian or personal representative of an incompetent person may generally authorize the medically appropriate withdrawal of treatment for the patient. So you remember that story back in 2008, that patient that we were taking care of in our ICU that ended up getting reintubated, even though that's not what any of us would have wanted. That patient ended up getting reintubated, only to end up dying just hours later on the ventilator. So, yeah, it took us 9 years to get that legislation changed. It was difficult, but we persisted. And the former standard was basically in case of developmentally disabled persons that you could not, it prohibited you from basically withdrawing treatment for the patients. Now, it's not that you can just say, hey, yeah, go ahead and do that. There are some criteria in place that we use to do that. Next slide, please, and I'll talk about that. So basically, it's one of these criteria, A, B, or C. So the attending practitioner and at least one other licensed independent practitioner certifies that the patient is chronically and irreversibly comatose, or the patient treatment would merely prolong dying, would not be effective in ameliorating, or nope, there you go, that's it. Or correcting all of the respondents' life-threatening conditions, or would otherwise be futile in terms of survival of the respondent. Or the treatment would be futile, virtually futile in terms of the survival of the respondent, and would be inhumane under such circumstances. So if any one of those things apply, then the provider can act on that. The guardian can act on that in concert with the provider's recommendations. Next slide, please. So we've already talked a little bit about this and the court-appointed guardian, but just to let you know, we want to make sure that you understand this. It's not just people who have developmentally disabled people, but it could be a patient that's a minor and unable to give consent. So just kind of recognize that. Next slide, please. All right, so this is a sample version of the Idaho Post. And if you look at Section A, hopefully you can see that well on your screen. If you look at Section A, it's designated to address your resuscitation wishes. Remember when I talked about those, there's a basically do not resuscitate or resuscitate. And then there's a little bit of information provided for the person, the patient to look at on there, as well as their provider as they're filling that out. Section B is just designated to address some level of interventions that we do, that we will take on with regard to your condition. Now, if you choose comfort measures, then we're going to significantly limit those things that we would do, because that's not what you want. You don't want all the, bells and whistles and the kitchen sink thrown in there. You just want to have a comfortable death. The next one is limited additional interventions. And basically that talks about just some of the basic stuff, but a little bit higher. It might mean that we could transfer you to ICU, but that doesn't still mean we would do everything. And then the last one is basically, I want everything done. Section C addresses some of the other areas. Oh, thanks. Section C addresses some of the other areas. And I'll tell you that there are efforts at the national level to create better consistency, and those things have resulted in a national post form that became available back in November of last year. And Idaho is, there's 2 states that have already adopted it, and Idaho is prepped and ready to adopt the national form sometime in the next, I'm just going to say sometime in the next few months. Don't have a timeline for that yet. Next slide, please. So here's just a little bit more detail on Section A and B. Next slide. Then on B, you can see how it talks about the artificial nutrition, hydration, talks about the antibiotics and blood products. And then it talks about, do you have an advance directive? And I guess the question is for you, well, why do we care if you have an advance directive if you haven't living well? Well, remember that this document is a summary of your wishes. It is a physician order, but it's not necessarily the be all end all of everything that you want. So if you have an advance directive, which we all should have an advance directive, then when you complete the living will, you want to make sure that that living will, sorry, when you complete the post, you want to make sure that that post is consistent with your advance directives. Or if it's not, if you're wanting to do something different with your post, that you update your advance directives. And then lastly, it has all the signature stuff on there. Next slide. All right, so hopefully I've helped illuminate the difference between a post and other ACP documents. Remember in your mind that advanced care planning is the big umbrella that has these things under it. There's the post, it's a provider order, has to be signed. In order to be active, it has to be signed by a licensed provider as indicated by statute. And in Idaho, that means a physician, a APRN, or a PA. And then the living will, the healthcare agent, the personal values statement, all of those things, they can be completed by you and by you only, if that's what you want to do. Next slide. So, question for you all, and you can put your answer in the chat. The Idaho Post is an advance directive. Yes, no, or I don't know what it is.
I'm seeing one yes so far.
Okay, and Diane, I'll address your question. I didn't see it till just now. I'll address that here in a second.
And make sure you are responding to everyone in the chat and not to one person.
All right, a couple more seconds.
Woohoo! Penny has it. It falls under the umbrella of the advanced directives.
So, honey, it falls under the umbrella of advanced care planning.
Oh, that's what I should have typed. I apologize. Because I know that it's not an advanced directive, but it falls under that umbrella. So I apologize for my miswording.
That's okay. So the short answer to this is no. It is not an advanced directive. And the reality is it's a physician's order. And like I said, both of them are advanced care planning documents, and this is kind of visually what it looks like. You've got the Idaho Post over here, and you got the advanced directives with the living will, drawable power of attorney for healthcare under that. All right, so let me, okay, yeah, keep on going here. There you go. Sorry. So let me address a question from Diane. So Diane just saw a PA for her new internal medicine doctor for the first time. She's healthy, she's active, she's a 75-year-old. And she told you, basically you have a post with a DNR, and the PA strongly encouraged you to rethink that and talk it over with your doctor. So let me tell you one of the things that the post document, and this is a general statement, the post document is indicated for patients with advanced illness and patients who have chronic illnesses or end of life advanced chronic illnesses. And where if I was to ask you, or somebody was to ask me as a healthcare professional, would you be surprised if this patient died within the next year? And if my answer was yes to that, then I may not think a post is appropriate. But if I was to say, no, I don't think I would be surprised if they die within the next year. I think that they probably will die within the next year. Then that person is appropriate for a post. So Diane, that's probably where your PA is coming from. And again, this is a personal decision. If that's the decision that you want, and that's the treatment that you want honored, then that's between you and your provider. Obviously, you would have had to have a provider sign off of this at some point, and you hopefully had a good discussion about why that was. The second thing I will say is, if I were you being healthy and active, even with a post form, I would still advise, if you don't have an advance directive, that you complete an advance directive that provides a little bit more detail to really help us illuminate what your personal values are, what your goals of care are, because it's not just as simple as, do we do CPR or not? I've had patients that have said, I do not want CPR, but I want aggressive interventions minus CPR. Well, how do we do that? Well, there's a lot of things that we can do in critical care that are considered aggressive interventions. If you come in septic and your DNR, we're not going to intubate you. We're not going to do compressions. But we may give you medications to help support your blood pressure. We may give you antibiotics. We may give you blood products. We may do all of these other things because those things were consistent with your values, but we still won't give you artificial respirations and compressions because those aren't. Does that help, Diane?
Mm-hmm.
Okay. Did that bring up any other questions from anybody else?
Rick,
You know, this is Mary Malott, and actually, I guess it's more of a comment, but sort of with a question in it. You know, as you're talking about all these things, does the layperson know, right, what all of these things mean? And even having that, discussion, I think it's really neat to have, like a video or, some sort of tutorial that really explains, what do these different things mean? What does cracking a chest look like? What does intubating, look like? That's one part of it. Then the other, that's kind of the question comment piece too, is in light of COVID, there might have been people that they weren't necessarily, in that 1 year out, but they had a chronic condition, right? And in this, with COVID, it just kind of exacerbated, things. And, that I think is something else that we need to, living through a pandemic, we need to stop and think about, those types of situations.
Yeah, that's a good comment. So I will tell you that formally, well, let me tell you about a resource. So if you type in National Post, POLST, that should bring you up to the National Post website. There's a lot of great resources there. One of those resources will tell you even more about what the Post is and who it's for. And it'll talk about the difference between that and advance directives. One of the other things is the National Post group. They did provide an official statement with regard to COVID-19 and considerations around creating a post. So people that elect to, they say that, look, I've got asthma. I don't know if anybody can mute Diane, but I think she's on the phone. Anyway, if you have a chronic condition like COPD, you have asthma, you have these things, and you think, you know what? If I get COVID, I've been reading all the studies, I've been reading the news, and if I get COVID, the likelihood that I die is 85%. And even if I don't die, the likelihood that I have a functional outcome, that's one of the terms that we use all the time in ICU, is we can save your life, but are you going to have a functional outcome? Are you going to be able to return to the quality of life that you had before, or even close to it? These people that created a post in the middle of COVID had some very informed discussions with their providers, and they decided, you know what, I'm going to get this document. Now we are in a different situation. Many of these people have already gotten the vaccine. They're fully vaccinated. They've got first one, second one. They're outside that 2-week time frame after their second one. So the likelihood that they get COVID is highly unlikely, and the likelihood that they die from, even if they get it, is even more highly unlikely. So now that person has another conversation to have with their provider. Maybe they want to take that document that they created and rip it up because they don't feel as vulnerable to death with the vaccine on board.
And I would also like to mention that you were given a link to the handouts on the Learn website, and all of the support sheets from the Honoring Choices website have been downloaded, and they did have a special COVID handout as well to kind of help navigate some of those questions.
Yeah, and there's also some great information about dementia and things like that and advanced care planning. So, it's a lot of information, but take some time to take a look at it on both Honoring Choices Idaho as well as National Post, and become informed. Not only it'll help you out personally, but it'll help those people that you serve. Other questions or comments?
Rick, it's Honey. I had a question for you. I hadn't heard like the concern about making sure that your advanced directives had that HIPAA element in it. Do the Honoring Choices, I'm assuming, has that language that you guys like in the ICU environment?
It does. And most statutes, when I say most, I don't know that all do. Most statutes will have some kind of language in there granting that access to the durable power of attorney for healthcare, but you can't guarantee that wherever you go. So if it's explicitly documented in your advanced directive, there will be no question that person needs to have full access to your medical record.
Great. Well, I think I'm going to update my advanced directives after this because I've never updated. I have the old version still, and I now think I want to change it. So that was a good presentation.
And I'm grateful for whoever came up with the old version. But I mean, if you think of what the older model 70s cars looked like, that advanced directive was created back in the 70s, I think. And we've got more technology. When you look at a car today, it's got all these bells and whistles. It looks great. It's going to meet your needs better. And that's the way I think of the Honoring Choices Idaho Advanced Directive. It's taken the studies that are out there, the things that we have learned over the last 30 to 40 years, and it's put all of those things into a very easily digestible document for the consumer. Other questions?
Oh, I actually have another question. I put it in the chat. So is the post, is it transferable? So I fill that out here in Idaho, but I decide I'm going to go back to Chicago and spend a month in Chicago. Something happens to me there. Is it transferable?
So most states have a
Reciprocity or
reciprocity. Sorry, a reciprocity clause. Idaho does, and that's one of the reasons why we're really pushing the national post, is because then when I move from state to state, not only is there reciprocity, but when EMS, if I happen to be visiting in Wisconsin and their post document looks totally different than the Idaho Post, and EMS shows up and they're looking at the Idaho Post in Wisconsin, they're going, where is that information? It makes it so much easier when the information is consistent as far as the formatting goes, when the information is consistent in language. And so that's one of the reasons why we're really encouraging people to consider adopting the National Post. And you don't have to adopt it out of the box. Idaho didn't. There was a few very minor details that we changed to ours. And so that's what we're moving to.
Thank you.
Yep. I'm sorry, I'm looking back at the chat again, and sorry I missed those two questions. Other questions?
My last question, Rick, I apologize, just because we don't run the same circles as much anymore. So there is some conversations now. Is there any future changes to the post, like being considered at the present time, or just keeping it as is unless we ever adopt the national one?
No, we are adopting the national one. And that's probably I don't want to make any promises. That's why I said over the next few months. I will have more information probably in the next couple of months that might give me a better indication of the timeline. But that's where we're headed. I don't know if you all knew, but there's been an effort in place that I've been involved with to move the Idaho Healthcare Directive Registry from the Secretary of State's office to the Department of Health and Welfare. And there was a large sum of money that was approved in the last legislative session in 2020. That is now coming to fruition. They put out an invitation to bid last December. That invitation to bid closed in January. They reviewed all the invitations in February. They made an offer to the vendor in this month, and that vendor accepted. So we now have a vendor. Idaho is going to enter the 21st century of advanced care planning. So this is going to be an awesome thing for those of us who work in the community. It's going to be an awesome thing. And when I talk about that, I'm talking about home care and hospice. It's going to be an awesome thing for clinics, for hospitals, and it's going to be an awesome thing for consumers because they're going to have a much easier way to upload their information, to access their information. One of the things I do want to mention, and I don't really have that much information on it at this point, but just to let you know, Idaho and 10 other states have some kind of language in their statute which limits the extent of an advance directive for a pregnant woman. Essentially speaking, they can't have a DNR when they're pregnant. That was challenged at the federal level. 4 women challenged the state of Idaho, and that was upheld by a federal judge. Now, I've already have some conversation and communication out there to legal, and so we're kind of trying to figure out what that's going to mean. I'm not necessarily supportive or opposed to that, but I got to understand what is that going to mean for us moving forward, particularly for those of us who care for pregnant women. We need to understand what are the tools that we can offer them with regard to advanced care planning. So just be aware of that. It's not a secret. I can't remember what site I saw it on, but you can probably just Google it and find it. And somebody asked about, having real life videos of performing CPR and intubating, things like that. I am certain that those things are available on the internet. Like if you Googled real life CPR or Googled real life intubation, you'll probably see more than you wanted to see.
Don't go to Chicago Med and watch them resuscitate people regularly.
Yeah, you can tell fake CPR because their elbows are bending instead of the chest is compressing.
Mm-hmm.
And so they're trying to protect that actor going, hey, dude, I'm not going to press on your chest all the way because that would not be a very kind thing to do to somebody who's conscious.
Yeah.
Yeah, they do a pretty good job of mocking it up though.
And unfortunately, many people think that that's how it works and that it's a very easy process and that we're all going to come back to life regardless of what else is going on for us. So
Other questions or comments?
Going to look pretty and clean, right?
Yeah.
It's not going to be the
It's not.
bloodshot and cracked ribs and everything else. Yeah.
Yeah, if you've ever seen childbirth on a TV show too, those babies come out and realistically, those babies look like, that baby looks like it's at least 3 months old. Because they don't want to show a newborn baby. It doesn't look pretty.
Yeah.
well, I think we have answered all of the questions unless anybody else has one specific. If not, I want to thank you, Rick, very much for your expertise and kicking off our inaugural launch of Learn Training. It was excellent, and I hope you'll come back as a speaker
Sure.
in the near future, especially as the new post is adopted. That would be very helpful to get an update from you. So thank you very much. And
I want to say thank you again to Dee. Sorry, both as the chair of our Community Education Committee and also as the sponsor of this series, and for believing in Learn with her heart and with her effort and with everything she does.